Welcome to this session. In today's session, we'll be talking about IPR. What is IPR? What are the different forms of IPR? And what are the laws which protect these intellectual property? So what is IPR? IPR or intellectual property rights. Now, if we just say IP, what is intellectual property? So there is no set definition of intellectual property, but still I'd like to define what is intellectual property. The property created by the application of human mind. It is non-physical, incorporeal, and it derives its value from ideas. That means the property which is created by the application of human mind, it is a product of your intellect. It is non-physical because it doesn't have an appearance. It's not movable. It's not immovable as well as it's not movable. So it is incorporeal. So just if you have any idea, you cannot say that it is your IP unless and until you express it in the form of some sort of expression. It may be in the form of a novel or it may be in a form of an invention. So whatever we say, intellectual property is intellectual property only if it is expressed in some form of, if your ideas are expressed in some manner. So we can say that it is non-physical, that is incorporeal, and it derives its value from ideas. Many people can have the same ideas, but one who expresses his or her ideas, it becomes an intellectual property of that person. And thus, a right occurs there. Now, you have to protect that right. We will see how we will protect our intellectual property. Now, there are two branches of intellectual property. If we broadly classify, there are two branches of intellectual property. One is industrial property and other is copyright. When we talk about industrial property, a number of things come under it, like the patent, like the GIs, like the trademarks. These all are forms of industrial property. Industrial property means the property which has an industrial application. And the other branch of intellectual property is copyright. Now, let's see what is copyright. Copyright, we can say, is a protection which is available to the authors, composers, artists, and designers for creating original works. So there is a qualification here, original works. You cannot copy something and say that it is my original work. Originality means that some sort of skill should be involved in it. Then only your work is original. So it is a form of intellectual property which provides exclusive rights to the creators to use or authorize others to use their works in relation to literary work, dramatic work, musical work, any type of artistic work, cinematographic films, sound recording. These all are forms of property which can seek protection under the copyright. And we have a Copyright Act which is available in India, under which we will be seeking protection. So we can say that copyright is the creation of a statute and it stands as a unique form of intellectual property. It creates a monopoly right which is restraining others means the whole world, from exercising that right, and it is also a negative right which is preventing others from copying or reproducing the work. If a copyright is given to you, that means you exclude the whole world from exercising your copyright act. That's why it's known as a negative right, because it prevents others from copying or reproducing the work. Once you get a copyright protection, you restrict others from copying that work or reproducing that work. It is also considered as one of the most significant catalysts in the economic progression. Copyright is a transferable right. Of course, it is a transferable right, and the owner can transfer this right by way of license, lease, or any other by way of sale for monetary consideration. So copyright can be considered as a group of rights which in turn enable the development of related industries. So in that manner, we can say that it is one of the most significant catalysts in the economic progression, because copyright is a transferable right. You can give your right to somebody else to gain some sort of economic benefit of it. So it is a significant catalyst in the economic progression. We can also say that copyright meets the changes brought by advances in technology of communication and reproduction, as also the emergence of India as an independent nation with its own aspirations and agenda for development. The act in India was first of all enacted as a Copyright Act 1914, which got modified by the Copyright Act 1911 of UK that was applicable at that time in India. And this act brought the changes in the advances by advances in technology of communication and reproduction, as also the emergence of India as an independent nation with its own aspirations and agenda for development. So, a complete revision of the law of copyright was effected in the form of Copyright Act of 1957, and it was further amended from time to time, and the latest amendment which we have seen is in 2012, which is also known as the 2012 Copyright Amendment Act. The Act of 2012 incorporated provisions of the WIPO Copyright Treaty 1996 and the WIPO Performances and Phonograms Treaty 1996. So, these amendments, they expanded the scope of related rights for the performers. Now, we will like to know what are the protection which is available under the Copyright Act. The legal protection of copyright has developed economic advantages to which sectors? To the sectors of, in the case of literary work, in the case of artistic work, in the case of cinematographic film and sound recording, and also in the case of computer programs. So, if you have a computer program, you can seek protection under the Copyright Act. However, copyright is given only for a limited period of time. That is, after the period of protection is over, that works comes into what is referred as the public domain, and every member of the society can freely access and use the same. So, certain other intellectual property rights such as patents and designs, they also have similarly limited time, which is also known as the term of the protection. The term of protection for Copyright Act is 60 years plus the term of protection of Copyright Act is the life of the creator plus 60 years. That means till you live plus an addition of 60 years, you get a copyright protection of your work for that many years. And then after the time is over, it comes into the public domain. So, anybody can access it and use it for the betterment of knowledge. Now, we come to a very important act, that is the patent right. The patent, similarly like the copyright, patent is also a monopoly right, and it is granted by the government to a person who has invented a new and useful product. In other words, it is a grant of some sort of privilege, property or authority made by the government for one or more individuals who invented a new article or a new process for making an article. So, patents, they provide incentives to the owner in order to give recognition to the creative work and as a reward for the marketable inventions. We can say patent is related to inventions. So, if you are inventing a new article or a new process, even a process of an article, even the process can be patented, process of making an article. Let me give an example, the process of making a dosa. So, if two people, they are making dosas in two different manner, the process of making dosa can also be patented. One person makes a dosa in a very tasty manner and he wants to get a patent for that process. So, he will get patent for the process itself, not for the end product only, but for the process of making dosa. So, that is how we invent a new process, and that new process can be patented under the Patent Act. For the conditions of patentability of a patent is the product or process must be new. That means novelty is a very important aspect to get patent. The second is it must be non-obvious. Third, it must be useful. And fourth, it must be capable of industrial application. So, unless and until your invention fulfills or your process fulfills this particular conditions of patentability, the government will not give you a patent. So, for that you have to fulfill the eligibility conditions of patentability, which is the product or process must be new, it must be non-obvious, it must be useful, and it must be capable of industrial application. Now, patents, they can be used to encourage the economic progress in the ways, because patent is also a tool for economic progression. So, it can be used to encourage economic progress in what ways? By technology transfer and investment, it promotes research and development, it activates the development of new technology and commercial activities, and also it is used for revenue generation. The law which is related with patents in India is governed by the Indian Patents Act 1970, which was amended by the Patents Amendment Act 1999 and the Patents Amendment Act 2002 and 2005. And latest, we also have patent rules of 2019 and 2021. The purpose of patent is to afford protection to the inventor for the invention for a limited period. What is that limited period? That is the period of 20 years in exchange for the disclosure of all the necessary knowledge to ensure its commercial working. It provides an exclusive right to the inventor for exploiting the invention, and it affords protection against unauthorized use of the invention by the third parties. So, the main objective, you can say, of national patent legislation is to accelerate the technological and industrial development of the country. Again, a very important IP is, intellectual property is, trademark, and we will be talking about the role of trademark, how it is important in the progression of economy. Trademark, what is trademark? Trademark is a visual symbol in the form of a word, a device or a label which is applied to articles of commerce with a view to indicate the buyers that the goods are manufactured by a particular manufacturer, as it is distinguished from similar goods manufactured by others. So, we can say, in other words, that trademark is a goodwill, because we have so many things in the market, and if you want to buy a thing from the market, how will you distinguish that brand from other brands? If it will carry some sort of symbol, some sort of expression, some sort of phrase which will distinguish it from the other forms of the same article in the market. So, as for example, let me give an example of Indira Gandhi National Open University. This university which we are a part of in IGNOU has got its own logo, and it's also got a phrase, Jan Jan Ka Vidyalaya, or the People's University. The moment you hear the word the People's University, it comes in your mind that it is IGNOU. So, there is a, you don't even want to see the trademark, the logo, of course we know the logo, but if the moment somebody says it's a People's University or Jan Jan Ka Vidyalaya, we come to understand that it is Indira Gandhi National Open University, and this trademark or this phrase, it distinguishes us from other universities. So, similarly, any type of visual symbol or any type of word or a device is a trademark which distinguishes one goods from another good, and it is because of that brand which you have been using it, you distinguish it from other goods. You can, in other words, you can say it is the goodwill, because you've been using that brand for a very long time, and now you know that this brand is very good, very reliable. So, you definitely like to tell it to by way of mouth to other people also, because I'm using this brand, I am studying in this university, and this university is better than other universities. So, this is how you distinguish the goods from other brands. So, the role of trademark in the economic progression is that it identifies the product and its origin, it guarantees quality products, it trademarks, it advertises the product also, it is like an advertisement for the product. It acts as a catalyst in marketing techniques. It increases customer loyalty, because you've been using this for a very long time and you have a loyalty towards it, that this brand is very good, so I will be using it for long. And if something new has been made of that same brand, then you would like to try, because the brand is of your choice. Also, it increases profitability. It prevents unfair competition. It reflects the product. It differentiates similar kind of products. It encourages the licensing programs. It initiates new products, and it also encourages collaboration among business community. Now, how did the Act come into being? In 1940, the then British government of India passed the Trademarks Act of India for uniform and systematic registration of trademarks in India, which came into force on June 1st, 1942. The Trade and Merchandise Act 1958, which came into effect from November 25th, 1959, it replaced it, and it became necessary to effect changes in the trademark law as India joined WTO, the World Trade Organization, as an original member in 1995, and it was thus obligatory now to bring the Indian law in consonance with TRIPS. Hence, we have the new Trademark Act 1999, which repealed the old act. And the 1999 Act is different from the Act of 1958 in two manners. How is it different? The shape of goods is recognized as a trademark here, and the trademarks are also now granted for services also besides goods. So, here in the new Act, we have now services also as a trademark. You can also, for services also, you can make a trademark, a logo for that, for hiring of services. The next very important IP is design. Now, design is also an instrument of economic development. First, let us understand what is designs. Now, industrial designs are also a type of intellectual property which is having a very good economic value. When similar products are competing in the market, design is the differential. The legal protection of industrial designs, it paves the way in the development of innovative and eye-catching designs. The legal protection of design accelerates industrial progress and fosters the economy. So we can see that because of designs, you can make yourself, you can say that this is my creation. You can have an industrial revolution because of a design, because a particular design, as we know that there are block designs, or even in the folks as a traditional cultural expression, a number of designs like the katha work or block designs, these are gaining a lot of popularity. So similarly, designs made by a person also, they gain a lot of popularity if they get protection under the Industrial Designs Act. Now, what is designs, as has been defined by the section 2D of the Designs Act 2000, which says that design includes some sort of shape, configuration, pattern, ornament, composition of lines, also colors applied to any article. A similar sort of color can also be considered as a design. If it is your, trademark, if it is your goodwill, or if it is your, you can say signature thing. So even colors can be applied to any article, and that can seek protection under the section 2D of the Design Act. Now the design may be a 2-dimensional or 3-dimensional, or it may be in both forms for any industrial process or means, whether manual, mechanical or chemical, separate or combined, which in the finished article appeal to and are judged solely by the eye. That means it should be an eye-catching thing, or it should be very appealable to the eye. For getting a design registered, it should be new and original. The person who makes the original design is known as the author of the design. He has the exclusive right conferred on a design, which is termed as the copyright in a design. The author of the design has the right to assign and transfer his right for good consideration by way of license, mortgage, etc. There are certain benefits which are available to the registered proprietor of an industrial design under the Designs Act 2000. They are copyright on registration. The proprietor of the registered design gets copyright on the design up to 10 years, which is known as the term of the product. 10 years from the date of registration as per section 11 subclause 1 of the Designs Act 2000. Apart from that, there is also protection from piracy. Piracy of registered design means infringement of a copyright in design, and it shall be unlawful if any person without the consent or license of the registered proprietor of designs use the design for any fraudulent or obvious imitation. So the registered proprietor has the right to claim damages under section 22 subclause 2 subclause B of the Designs Act 2000. Another very important type of intellectual property is the GIs, the geographical indication. It also helps in the economic progress of the country. GIs, as the term itself speaks, the geographical indication is a name or sign used on certain products or goods that have been originated in a particular geographical region. GI denotes that the product originates from a particular place and the product has a reputation or certain qualities because the product derives its qualities and reputation from that place. So the economic importance of GI as kind of IP is the place of origin, the quality product and reputation, and also represents the common heritage. A very good example of GI is the Nagpur ke Santre. Nagpur is famous for its oranges because of its place of origin. Similarly, Kolhapur is famous for the Kolhapuri chappals, and it is because of the quality of the product and it is having a reputation. And similarly, we have other things like the Banarsi sari, the Banarsi pan, and these all relate to the place of origin and the quality product, the product of its quality. So nobody can think of imitating. If somebody imitates the GIs, it will be considered as an infringement of GI. So the quality of the product and its reputation is related with the GI, and that is why if a product is related to a place of origin and has a quality in it and has a reputation in it, and if it represents a common heritage, it can be protected under the GI, geographical indication. Intellectual property is the traditional knowledge or the indigenous knowledge, and how this traditional knowledge or indigenous knowledge helps or contributes to economic progress, we'll be talking about that. Traditional knowledge is a kind of IP which has gained recognition in the recent period. It was always there, but it has gained much, momentum now in the recent period. The emerging importance of traditional knowledge, it focuses on the attention of the WIPO. As per WIPO, World Intellectual Property Organization, The term TK or traditional knowledge, it refers to inventions and creations which are based on tradition, which is the result of intellectual activity in the following areas. What are those areas? Industrial and scientific. So we can say that traditional knowledge is the kind of IP which has gained recognition because of these activities, which are, one is the industrial and the second is the scientific. The other important aspects of traditional knowledge may include literary or artistic fields. As we know, traditional knowledge, it can be transferred from generations to generations, and they are concerned to a particular or attributed to a particular community. Speaking about the economic importance of traditional knowledge, these are intangible assets. They are also the source of income of the local people. They have ecological benefits through agriculture, and they also have role in other fields like artistic fields or like a folklore or artisans or handicrafts. So they have an economic importance too, because the local people are solely dependent upon these, the traditional knowledge for the food. They are solely dependent for the bread and butter on these aspects. The source of income is completely relies on their traditional knowledge. At last, I would like to say that we have seen the different forms of IPR. But what is very important is that there should be a harmonization of IPRs. As we see that because of the diversity in nature and the extent of intellectual property, the legislation or the law has resulted in efforts by various organizations to harmonize them to minimize the conflict among the nations in relation to the IP matters. So, signing of TRIPS agreement, it resulted in establishment of minimum standards of protection and enforcement of IPR. So, it is very important that there should be a harmonization of IPRs, and at the same time there should also be a balance of the private right of the person and the public interest. Now here the public interest means that we all have the right to get benefit from the IPR of another person. So the private right of the person who has created the thing has to be balanced with the public right of the masses who has the right to enjoy the benefits of the scientific temperament of one person. So we can say that there should always be a harmonization of IPRs. We should balance the private right of a person with the public right. With that, I come to the end of the session. I hope you've enjoyed this session. Thank you so much.